go. Okay. Appreciate everyone for joining today. We've got a great presentation with Jim Sikora. He's a shareholder at Landerholm. And if you're not familiar with Landerholm law, you should be. They focus on employment law and really supporting a lot of business owners, executives, and all the different facets that you deal with on a day-to-day basis. So you may have worked with them in the past, but if you haven't worked with Jim specifically, he's there to represent and advocate for employers, does a lot of work with the state and federal courts, EEOC, which is always a fun acronym that I get to hear about every once in a while, Human Rights Commission, Bureau of Labor and Industry, Holy, and then the Department of Labor and Industries as well. So who doesn't love L&I? So I'm going to pass the presentation on to Jim here in just a second. So he's going to control the slides and go through. Again, just as a quick reminder, if you do have any questions, feel free to use the chat log. We do have a couple polls during the presentation. So we have some questions we wanted to ask and try to keep the engagement going that way if possible. But really excited to get everybody on the call today. Again, it's a pretty interesting time in our world, and we were kind of curious to find out how many people would show up after the election results started to roll in yesterday. So Jim, go ahead and take it away.
Thanks, Tyson. Thanks for that introduction, and thanks to everybody for being here. I know there is a lot going on, and I was joking with Tyson yesterday. I was wondering how many people would sign up, given that we were doing this 9:30 in the morning after an election. I was quite impressed that we have this many people signed up and this many people here this morning. So I want to maybe just get started by running one of those polls. Tyson, is that something you can do?
Yeah, absolutely. I'll do that right now.
In terms of just to get a sense of how many employees all of you have that are here today, and as well as whether you have employees in Washington, Oregon, or both, just to kind of see what your issues might be, and so I can try to focus on those a little bit more as we go through the presentation.
Yeah. Looks like everyone's got this figured out. So just click on the options that you have there. There's multiple choice actually in the second question, just trying to understand where all of your employees might be. And we'll keep this open for another 10, 15 seconds or so and be able to share those results.
Okay. So it's looking like we have a pretty good spread from folks that have anywhere from 1 to 25 employees, a big chunk in that 25 to 250 range, and a couple of larger employers, and then primarily Washington-based, but a fair number of people that have employees in Oregon as well. So that's really helpful. Thank you for sharing that information. So I want to now move into just kind of a introduction, and before I get to that, actually, I just want to give the disclaimer here that I'm not here to give legal advice. This is intended to be informational. Everything I'm talking about today is based on the information that I have right now. I try to keep things as current as possible, but we are in these unusual times this year where we've seen developments at just a breakneck speed, where I did a presentation about a month ago, and the night before I did the presentation, there was a big dump of regulations. I don't think anyone did that last night. That'd be pretty cruel to dump something like that on election eve, but just need to give you that caveat that there is a lot of uncertainty. So it's always good to keep an eye on developments to the extent you can. So with that being said, I want to just maybe go back and talk a little bit about, or briefly about, what have we seen in 2020? And I know it's kind of an absurd question to ask, because I think we've seen just about everything. And it seems like there's going to be quite a lot more happening in the next days and weeks as we see how the election shakes out, as well as some other things. But stepping back from the pandemic and the election and some other things going on in the world, and more focusing just on employment law and how it affects businesses and employers, it has obviously been a very busy year on that front as well. And one of the interesting things about the pandemic is it really has had a huge effect on employment law, and a huge effect on how businesses are operating on a day-to-day basis, and what employee relations are like, and just what the the workplace is like in general and how it's functioning. And one of the things in preparing for today that I was sitting down and thinking about is um, if someone came to me this time last year and said to me that we would have a federal paid leave program passed with broad bipartisan support in a matter of days and then implemented it in a matter of weeks, I would have laughed you out of the room. But that's exactly what happened earlier this year with the Families First Coronavirus Response Act, which we'll talk a bit about today. And that is just frankly something that's unprecedented. And surprisingly, it went fairly smoothly, which is quite impressive given the breakneck speed within which that development occurred. So we had that just dramatic shift, almost an overnight shift earlier this year when the pandemic started with the lockdown, a lot of layoffs and furloughs as businesses responded to the lockdown, some of the legislation like I talked about with the Ffcra. We had all that earlier in the year, and then we kind of settled in, or at least it felt like we settled into just kind of this routine as we moved into the summer months and into the fall. And we're obviously seeing a bit of a, well, actually more of a bit of an uptick in the cases right now. So that could change the dynamic. But what I have noticed as we've progressed since that initial phase in the spring from the employment law perspective is that some things like litigation are starting to increase now as some of the fallout from the earlier events of the pandemic are starting to catch up with us or occur now that the dust is settling, so to speak. So I'm seeing a bit of an uptick in claims, just both personally and also reading about that in a lot of the legal news publications that I follow. And those claims tend to be centered in a couple of key areas. One is in relation to layoffs or furloughs or other employment losses that occurred earlier in the year or earlier this summer as businesses responded to the lockdown and dealt with a dramatically changed economic environment at that point in time. Other area we're seeing some litigation is in leave-related type claims. So things like the Ffcra or other forms of paid or protected leave that people might have been denied or felt like they were wrongly denied because they needed some time away from work for COVID-related reasons. And then the third category where we're seeing some litigation is in relation to reports of safety concerns that employees had allegedly made in the workplace regarding COVID, and then trying to allege, and maybe some of them are actually legitimate, I don't know, that the employer turned around and fired that person because they raised that safety concern. And one of the key areas of risk from the employer's perspective, both currently in relation to the pandemic, and I think just generally in the employment world today, are those retaliation or whistleblower type claims. I saw a recent statistic that in 2019, 50% of the charges that were filed with the EEOC involved some form of retaliation allegations. That's something that's becoming increasingly common just in general, but also particularly in relation to COVID and some of the safety concerns and issues that are related to COVID in the workplace. And in conjunction with that increase in litigation, it's interesting because in the beginning of the pandemic, I had so many people that when I were talking to them would say, well, I can't imagine anyone would ever really sue over this decision. And they'll just understand that we had to make this decision given the unique circumstances we were in at the time. And I agree with that. And that's a very understandable perspective to have and a reasonable one, frankly. But now we're starting to see some of those decisions that were made in the context of March and April being questioned now without that context that we're all living back in March and April and early May. And kind of the classic, people have short memories, not necessarily remembering that context. And now it's easier to second guess a decision that was made back in March and April, when we're not in that kind of heightened lockdown period that we were then. So now that I covered kind of some of the fallout we're seeing, I want to also just talk about some positives, at least from my perspective. And I do think, even though we've been through a difficult year, that there were some positives that came out of this. And one of the things I was personally very impressed by and encouraged by is just how tirelessly businesses and business owners and management and HR professionals worked throughout this year to basically take care of their employees. So I saw so many people that were trying early in the pandemic to make sure that employees that were furloughed were able to get their unemployment benefits and to help those employees, and then making efforts to try to keep people employed where they could while also keeping a business operating, and to protect their employees' health and safety. That's been really encouraging. And to me, that really highlights how adaptable American businesses are, and kind of the entrepreneurial spirit of American businesses that I think sometimes gets lost in the shuffle of everything else and the noise that's going on in the world today. So what do we expect in 2021? I'm not going to sit here and tell you I can have any confidence in predicting what will happen in 2021. I think, if anything, I learned this year that that's a bit of a fool's errand. I think the one thing that I can say is, obviously there's uncertainty in that the ripple effects of this year are going to be significant. What those effects will be and how significant they are remains unknown. One of the big things that businesses are looking at, or should be looking at and evaluating now, is how are we going to operate moving forward once we're through the pandemic? I think we all expect that we're going to be in this for some period of time longer. How long is unknown, but what's the workplace going to look like as we move forward and hopefully get a vaccine or able to move back to some form of a normal life? With that, I want to, Tyson, can you throw up that poll about remote work?
Yeah, it's not coming up. Give me one sec.
So one of the things I see is, Tyson brings this poll up. You'll see that, just kind of curious what you anticipate as a company doing in relation to remote work as we move out of the pandemic. Are you going to maybe return to some form of just primarily in-office work, a hybrid, maybe evaluate mostly a remote workforce? And that's kind of one of the big questions, and kind of curious what people are thinking about at the moment. So we're going to let that run for a few more seconds here.
Mm-hmm. Yeah, we'll get another about 15 seconds or so.
Okay. So it looks like more than 50% are evaluating some form of a hybrid approach. So it'll be, still have on-site workers or in-office workers, but also have some flexibility for remote. We only had one that said mainly remote workforce, and then a sizable majority that either said no remote workforce or unsure. So thanks for responding to that. That's interesting information. I kind of personally anticipated that most of you would say hybrid. I think that's what a lot of businesses are expecting. But these are the types of the key issues that I think need to be evaluated now. So you're able to be ready to adjust and roll with the developments that occur in the pandemic as those occur. I think there's a real risk of being caught flat-footed if you're not evaluating these types of issues now and as we move forward, whenever the pandemic is finally over. One of the things that I see, and is completely understandable, is that we're now operating in an entirely different world in relation to how the office functions or the workplace functions than we were a year ago. And there's frankly going to be some inherent weaknesses or gaps in your policies and procedures when it comes to employment risk just because of that. And being able to sit down today and evaluate, okay, what is our situation today? What do we need to improve? But also, what is it going to look like in 3, 6, 9 months, and then even beyond that, so you can prepare from an operational standpoint, just to keep the business running, but also from an employment risk standpoint and just general legal risk standpoint. So if you need to update policies and procedures, you can do so, and you're prepared, and you're not caught flat-footed, and you're not caught behind your competitors as we move and evolve from today. And then also, I think it's important that those issues are addressed just from an employment retention standpoint and an employment morale standpoint, because a lot of employees are finding that they enjoy remote work or they don't. So being prepared to navigate those issues as we move forward will be critically important for that retention, that recruitment as well. The other thing I would expect to see in 2021 is some form of continued push for employee protections. I'm fairly confident this will occur at the state level. We're not going to see really much of a change at all, if any, in the approach that Washington and Oregon are taking to being aggressive in advancing employee-friendly regulations and laws. The federal level obviously is the big unknown at the moment. Will the current administration continue for another 4 years, or will there be a new administration in January? That will have a big effect on whether we see a push at the federal level or not for expanded employee protections, or maybe a continued emphasis on a slightly more business-friendly approach to the regulatory environment in the employment world. But one of the areas or issues we're seeing currently in the area is the Oregon Osha regulation that we'll talk about a bit later for workplace protections in relation to COVID. And I would expect we'll see something similar in Washington in the future, as well as kind of a continued push for employee protections in the workplace in relation to COVID. So with that, I want to move on to talk about the Ffcra. I mentioned the Ffcra at the beginning. It's the law that was passed earlier this year that most of you are probably familiar with, that provides job protected leave for certain employees who are unable to work for COVID-related reasons. It applies to employers who have fewer than 500 employees, and there's a couple of small exceptions for small employers with fewer than 50 employees to some parts of the law that apply in narrow circumstances. This law is only currently in effect through December 31 of this year. So the big question right now is, will it be renewed? I haven't seen reliable information on whether there's a current push to renew the law or not. I think the election has probably been the reason why we haven't seen much discussion on that front. But there are some indicators that suggest that the law will be renewed. Number one, a study came out within the past week or so that showed that the availability of paid leave resulted in a significant decrease in the number of COVID cases. I believe the statistic from the study that it resulted in it being the availability of paid leave resulted in approximately 400 fewer cases per day per state. I don't know how accurate that is. I'm not a statistician, but that seems like a lot. And if it's even reasonably accurate, then that would suggest that there could be a push and a motivation to extend the Ffcra in some form into next year. The other thing that suggests that it might be extended in some fashion is the business community hasn't been overly critical of the law. Obviously, there were some concerns from the business community early on and ongoing about some provisions of the law, but there hasn't been a strong opposition to it from the business community. So those two things to me suggest that there's a reasonable chance it will be extended. Probably no more in the coming weeks as we see how the election and some of the other issues at the federal level shake out, but something to keep an eye on because it is currently extended to expire on the 31st. So with that being said, I want to just touch briefly on some recent regulations or recent regulatory updates under the Ffcra. I know there's currently not that much time left for employees to take leave under the FFCRA, but I am seeing an increase in the number of requests as we move closer to the end of the year. Lots of employees have used up all their PTO, cases are increasing, and then there's just no way around that a lot of parents are struggling with remote work. So there seems to be a bit of an uptick in the number of requests under the FFCRA. So it's still important to be aware of some of these issues so you can process those properly and you don't find yourself in that group of employees who are facing litigation that I mentioned earlier. So what happened is regulations were rushed out in early April when the law went into effect. There was some litigation out in New York over some parts of the litigation, or some parts of the regulations, excuse me, and a judge invalidated portions of the regulations. So the U.S. Department of Labor rushed out some updates to the regulations, which are actually very helpful from my perspective. So I want to go through a couple of those real quick. The first is a work availability requirements. The original regulations required that the employer have work available for an employee in order for the employee to be eligible to take leave. Seems pretty common sense to me. If you don't have work available, if the employee doesn't have work to do, what are they going to take leave from? I don't know the answer to that question, but apparently a federal judge took issue with it and invalidated that portion of the regulation. So DOL came back in the recent updates and said, no, we're sticking with this. If we didn't require work be available for an employee to take leave, we could just have some frankly absurd results. So I think that's good. That makes sense to me. And so if there is a situation where some employees are furloughed temporarily, that's the type of situation where there is no work available. So even if they do have a reason to take leave for a COVID-related reason, excuse me, then they're not going to qualify because they can't take leave from the work that's not available. One note that the DOL kind of cautioned employers, what I call the don't get cute rule. Don't try to get cute and make work unavailable if you think an employee is going to take leave. The work being unavailable has to do to business reasons. It can't be a result of some kind of creative scheduling situation where all of a sudden someone's not on the schedule next week or the week after because you know they're going to take leave or you anticipate them taking leave. The second update under the regulations is related to the definition of a healthcare provider for purposes of the exemption in the FFCRA for certain healthcare providers. The FFCRA allows healthcare providers to avail themselves of an exemption for certain employees taking leave under the FFCRA for the very understandable reason that it's important that the healthcare system has employees available to treat people who have COVID right now. The original regulations included a broad definition of who or which employees would be considered a healthcare provider. The DOL rolled that back. And now that definition focuses on employees who are directly involved in patient care. So, kind of your nurses, your nurse technicians, those types of folks, or employees who are integral to the provision of services. So they might not be face-to-face providing direct patient care, but they're in the background in some fashion and they're critical to the actual provision of care to the patient. And so that could be an employee like a lab tech. So they're in the background, they're processing COVID tests or something like that. Without them being there, the system starts to break down, the ability to provide treatment starts to break down. So the DOL said, it's fine, those people or those employees are considered healthcare providers. They fall within the exemption. And if you as a healthcare employer need those people there, you can avail yourself of the exemption. Obviously, if those employees have COVID, you probably don't want to avail yourself of the exemption and you want to allow them to take the leave or stay home, whether it's under the FFCRA or paid sick leave or something else. But The exemption is particularly helpful in the context of childcare leave, because that can be an extended period of leave, and that could leave you as a healthcare employer without a big group of key employees that are necessary to provide care to patients. Some employees who don't fall within the exemption are your IT professionals, kind of your building maintenance staff, your human resources personnel, cooks, food service workers, those types of folks that keep the operation running, so to speak, but they're not integral to the actual provision of medical services. So the next area addressed by the updated regulations is intermittent leave. Intermittent leave is available under the Ffcra. So intermittent being that maybe someone takes leave Monday and Wednesday, but they work Tuesday, Thursday, Friday. The original regulation said that the employer has to consent to intermittent leave. The federal judge in New York took issue with that. The DOL came back and said, no, we're going to stick with that. So the current regulations still allow the employer the discretion to allow intermittent leave or not. Whether intermittent leave is available, even if the employer consents, depends on whether the employee is working in the office or at the worksite, or whether they're working at home. If an employee is reporting to the worksite or reporting to the office, intermittent leave is only available for the child care leave portion of Ffcra leave. It's not available for the emergency paid sick leave portion of the Ffcra, which makes sense because, again, like the example of the healthcare provider, if someone has COVID or they have a family member who has COVID, and so they might have been exposed, then you don't want them in the workplace. The goal is to keep those people out of the workplace to help reduce the risk of transmission, both in the workplace and generally. In terms of childcare leave, so your situation where an employee needs to be at home to help a child with remote schooling, or that child's other childcare isn't available because of COVID, intermittent leave is available, but the employer has to consent, even if the employee would be reporting to the workplace. In the context of hybrid schooling, and I believe some local districts that aren't already doing in-person or hybrid schooling are looking at moving to a hybrid model in the near future, where kids are in school certain days in person and then they're at home other days doing remote learning. It's important to understand that if an employee needs childcare leave to be at home with the child on those days when the child is doing remote learning, so let's just say the child's doing remote learning Monday and Wednesday, they're at school Tuesday, Thursday, Friday, the employee's use of leave to be at home with the child on Monday and Wednesday, assuming they qualify to use leave for that purpose, is not intermittent leave, because each of those days, so Monday is one qualifying event under the law, and Wednesday is another qualifying event. So the employer's consent is not required for leave in that circumstance. In contrast, where the employer's consent would be required is, let's say the employee's child is doing remote learning 5 days a week. The employee wants to use leave on Monday and Wednesday so they can help with remote learning, and then the employee's spouse is going to help on Tuesday, Thursday, and Friday. The use of leave in that context is intermittent leave, because the child's remote learning period is a single qualifying event. So that's something to keep in mind if you have employees asking about intermittent leave for childcare reasons, where your consent is required for them to take intermittent leave, and then when it's not considered intermittent leave and they can take it if they otherwise qualify. If an employee is working from home, they can take intermittent leave for any reason. So whether it's the paid sick leave portion of the Ffcra, their childcare portion of it, but you as the employer still have to consent. So you still have the discretion to allow it or not. So the final update in the regulations that I wanted to cover is the documentation requirements. Employees are required to provide certain documentation to take leave. The original regulations required that they provide it before they took leave. The updated regulations require that they provide it as soon as practical. Seems pretty reasonable, but just something to keep in mind. So we talked a lot about childcare leave already. I want to cover some recent Department of Labor guidance on childcare leave under the Ffcra. Because I think it's helpful because that's one area where a lot of employers are seeing a fair number of requests for leave. The first seems kind of obvious to me what the answer would be, but apparently it wasn't to everybody because I got a lot of questions about it and there were a lot of employees asking questions about it, is must the employee actually care for the child if they're going to take leave under the Ffcra? And the answer to that is yes. There must be an actual need and there must not be anyone else that's available to care for that child. So if there's someone at home, a spouse, other responsible adult who can care for that child, and the employee wants to take childcare leave, in that circumstances, they're not going to qualify for it because they don't actually need to care for that child. So the next item addressed by the DOL's guidance is, when is a child's school considered closed for Ffcra purposes? And one of the questions early on in the school year was, is the school considered closed when it's engaged in remote learning? And the reason that's important is because childcare leave under the Ffcra is only available if the school is quote unquote closed. And in the context of remote learning, the school is considered closed if the child is required to do remote learning because there's no other option. So the physical school is closed because the child can't go in. The child's still participating in school, but because they're not actually there, the school is considered closed and the employee could be eligible. If the school is operating on a hybrid attendance basis, the school is obviously considered closed for purposes of that child on the day the child isn't at school and they're engaged in remote learning, and it's considered open on the days that they can go in. And then the next question is, what happens if the parent has a choice, or the school gives the employee a choice between remote learning and in-person learning? If the parent chooses remote learning for whatever reason, if it's because they're concerned about the child's safety and going to school, but they have the option to allow the child to go and actually attend school in person, and the school is not considered closed for Ffcra purposes, and the employee is not eligible for childcare leave under the Ffcra. You could decide in that situation that you want to allow the employee to take leave. Perfectly reasonable. I have no problem with that necessarily, but just keep in mind, if you make that decision, that might and probably will affect the availability of the tax credits under the Ffcra. If you're not aware already, because this is a paid leave, so the employers have to bear the initial expense. The law includes a provision that allows an employer to seek tax credits against the employment taxes, the federal employment taxes that are paid, to help employers recover that cost or offset that cost. So if you allow leave in a situation where it's not permitted under the Ffcra for whatever reason, that might affect your ability to avail yourself of that tax credit should the IRS ever come knocking on your door and conduct an audit. So with that, I want to move on to some discussion of disabilities and COVID-19 and some guidance from the EEOC that I thought was helpful. And by the way, I've referenced quite a few different guidance documents from various agencies. If you want to copy those, you can't find them, just shoot me an email and I'll get them over to you. They're actually pretty helpful as references in the event that these types of questions come up in relation to COVID. So I think it's important to go through some of these because disability law is very important in this context because we're dealing with a medical condition. And so that directly implicates both the ADA at the federal level and then corresponding state law on disabilities. And the EOC released a series of questions and answers that I thought are helpful. And so I just pulled a few out that I thought were good to know and particularly relevant. So the first is, can you require a doctor's note for an employee to come back after they've had COVID or been exposed? The answer is yes. I've got a lot of questions on that. There seems to be some uncertainty or maybe some misinformation floating around out there about that issue. But from the EOC's perspective and the perspective of disability law, you can require a doctor's note. The CDC currently recommends that you don't if the employee has difficulty providing it or if the healthcare system's kind of overburdened, but you certainly can from the perspective of the EOC. So the next one is, can you require a COVID test? The answer to that one is also yes, provided that the test is administered in compliance or consistently with public health guidance. The EOC notes that you should make some effort to verify that the test is considered accurate and reliable. So don't buy something off the street corner. Do a little bit of research. Make sure if you're going to do testing, especially if cases worsen in your situation where you conclude that you need to do some testing, make sure that you're going with something that appears reasonably reliable and accurate. One of the questions or the big questions out there right now is when we get a vaccine. I'm going to say when because I'm a perpetual optimist, but when we get a vaccine, can you as an employer require employees to get the vaccine? There's a lot of discussion about this in the employment law world. The consensus seems to be yes, you can require it, provided that there's some exceptions for people with disabilities, religious considerations, those types of things. But stay tuned on that. I'm sure we'll see more developments on that, but the consensus seems to be yes. This is an interesting one that I have seen a few times. And it's whether you can ask an employee whether any of their family members have had COVID symptoms or actually had COVID-19. The answer to that is no. And this, I think, is surprising to some people because you're required as an employer to screen employees for certain things as they come into the workplace. But the distinction that's important here is focusing any questions that are asked of employees about exposures on whether they had contact with someone that had COVID or had contact with someone that had COVID symptoms, not asking whether a family member had COVID or a family member had symptoms. There's a small distinction there that's important under a federal law called the Genetic Information Non-Discrimination Act, that says that you can't ask an employee about their family members' medical conditions. So if you have a questionnaire or some type of screening mechanism that you're using for employees, which you should be using if you're not, just make sure that the questions you're asking are focusing on the employee's exposure, not on whether a family member actually has symptoms or has COVID. So the next question is, what can you do if an employee refuses answering questions about exposures, or maybe they don't want their temperature checked, or they don't want to be tested for COVID? The EOC says you can exclude them from the workplace. Given the current state of emergency created by the pandemic, if someone's not going to cooperate with those types of allowable and permissible screening measures, then they could create a safety risk for the workplace and you can exclude them. Both the EOC and I would recommend that you try to work it out with the employee. A lot of these types of objections I've seen are driven by fear. and uncertainty. And oftentimes a conversation with the employee to understand what their concerns are can help resolve the situation. But if you can't resolve it, you are, from the legal perspective, allowed to exclude that person from the workplace. So next question is, do you have to accommodate an employee who has some type of pre-existing disability? Let's say they're at higher risk for COVID-19, and they're concerned about coming into work. The answer to that question is yes, you may possibly have to accommodate them, depending on whether it would create some type of undue burden and whether it would still allow them to do the job. So some potential accommodations that could apply would be things like removing some marginal job duties from the employee's job to allow them to continue to perform the job, and that removal of those marginal duties might allow them to perform it more safely without a heightened exposure risk. So if someone has an underlying condition that puts them in a high risk class and they have a lot of face-to-face interaction with people, maybe you can move them back into another room where they have less face-to-face interaction, but they can still do all the essential functions of their job. Also maybe temporarily transfer them to a different position, modify work schedules, shift assignments, things like that. All those types of things that might allow the employee who has that underlying condition to perform the job, but also reducing the risk that they're going to be exposed. The EOC really recommends flexibility here. I think that's a good practice, both from a legal risk standpoint and just an employee relations, employee morale standpoint. Everybody I've talked to has been very flexible here, but that's not only in some cases kind of the right thing to do, but also the legal thing to do. Also keep in mind, for all of those of you who are in Washington, there is the high risk worker proclamation issued by the governor that requires certain types of accommodations as well for employees who fall into the high risk category set by the CDC. So that's a state level consideration to keep in mind as well. One comment on high risk workers, there has been a tendency, or maybe a thought by some, to automatically just tell or recommend to employees who are at high risk to stay home, or take other measures to try to protect those folks. From the legal perspective, that's frowned upon. Generally, what the law requires employers to do is allow the employee to decide whether they want to work or whether they want to request accommodation. So kind of discourages that paternalistic approach, even though you might be looking out for the best interest of the employee, and puts that decision in the hands of the employee, him or herself. This is another one that's come up quite a lot. You have an employee who doesn't need an accommodation. They don't have a disability, but they have a family member at home who's in a high risk class. Do you have to accommodate the employee because of the family member's disability? From the legal perspective, the answer is no. The ADA does not require you to accommodate an employee for a family member's disability. Obviously, there's always that question of, do you want to remain flexible in these circumstances? But that's not a legal consideration necessarily. That's more of a employee relations or business consideration. Okay, this is kind of a long question, so I'm going to try to summarize it a bit more efficiently. But the gist of the question is, if you're flexible now and you're allowing employees to telework, do you have to allow an employee with a disability continue to telework or work remotely after the pandemic is over because of their disability? The answer to that question is no. What you will do in that situation where an employee who has a disability, and this is common with conditions like anxiety or depression, an employee wants to work from home and they ask to work from home as an accommodation for a disability at that time, you evaluate it, that request based on those circumstances at that time. Just because you're doing it now doesn't mean you're going to have to do it in the future when the pandemic's over. The one question or issue to keep in mind if and when, I think it's more likely when these types of requests arise in the future, is has the ability of the employee to work from home all this time made it more difficult for you to take the position that they can't work from home? I think the answer to that question is probably yes. Many employers in the past had concluded that people needed to be in the office to do the job, and they weren't going to accommodate an employee by allowing remote work. I think that was a very reasonable decision. I still think it's reasonable, but has our experience over the past couple of months maybe changed that dynamic? I think the question's inevitably yes. I'm not saying you have to allow it, but it's just something to keep in mind as those requests arise in the future. Kind of a variation of that question is, if you've relaxed some of your performance standards, let's say you have a production expectation of employees and you've reduced that temporarily given the circumstances, do you have to maintain that reduction or that adjustment in the future? Or in other words, does the change now change the nature of the job going forward on a permanent basis? The answer to that is no. The EOC recognizes that these are temporary accommodations that you're making because of the pandemic, and they're not going to have a preclusive effect after the pandemic is over, which is good. And then the final question is, if you're remaining flexible or you're taking a flexible approach and you're allowing or providing benefits to some employees because they have school-age children at home, whether due to school closures or childcare, whatever it might be, is there a risk of sex-based discrimination? The answer is yes. So say, for example, you have a couple of female employees, you allow them to stay at home with their kids or modify their schedule, whatever that might be, and then you have a male employee who comes to you and asks to have the same flexibility, and you say no, that's going to create a risk of sex-based discrimination. So you want to keep those types of things in mind as you get those types of requests.
So Jim, a question came in that's somewhat similar to this, but it's also related to something else in the past. I was going to hold off on it till the end, but they were asking a question about how do you know, or how do you, I guess, confirm that an employee has someone at home and available for childcare?
It's a great question. I've gotten that one many times over the past couple of months. So what you're required to do under the Ffcra is have the employee make that representation in writing. If they make that representation to you in writing and you don't have any reason to question it, then you have to go by the representation. It's not ideal, but the law is allowing you to reasonably rely on that representation, and you go with that.
Perfect. Thanks so much. That's good.
All right. Feel free, if you have any other questions on that, to either ask them now or you can shoot me an email after the presentation. I'm happy to answer them. Washington overtime regulations, they were updated July 1 of this year. There were updates to both the job duties part of the overtime exemption and the salary basis requirement. The job duties updates were a positive set of updates in my mind because they brought the job duties requirements in line with the federal requirements, which simplifies things from a compliance standpoint for employers. Previously, there were some differences between Washington law and federal law that made it kind of difficult in certain situations to comply. So now those are similar. The salary threshold is the perhaps more negative update from the employer standpoint. That increased as of July 1, but it's still currently below the federal threshold of $685 per week, or about $35K annually. The big change that's coming in a few weeks is, as of January 1, the Washington threshold is going to increase again, and it's going to bump up above the federal threshold. So as of Jan 1, for those of you with 1 to 50 employees, you're going to the salary threshold is going to go to the $827 per week, or about $43K per year. And then for those of you with more employees, so you have 51 or more, it's going to bump up quite significantly to $965 per week, or about $50K per year. So if you haven't already started to look at your salaries for your exempt employees, now is a good time to do so, to make sure that they're going to be at that threshold if you want to keep them exempt. If they're not at the threshold, you need to look at whether you want to move them to non-exempt or maybe make adjustments to pay to bring them above that threshold. If you're going to do that evaluation, which you should, obviously, I also suggest that you look at your job descriptions just to make sure that they're accurate from the perspective of what the employee does on a day-to-day basis, and they're also compliant with the job duties requirements. You want to make sure that their employees are continuing to do their necessary duties to satisfy that exemption. So again, keep an eye on that. Coming up very soon. I'll be here before we know it. So you want to make sure you looked at those 2 items in preparation for Jan 1. There has been some developments with Washington paid sick leave. There was some confusion that arose in a couple of areas after the law became effective a few years ago. So the Department of Labor and Industries released some guidance on that earlier this year. The first pertains to cash outs. The department notes that employers cannot regularly cash out paid sick leave throughout the year. They can only do so at the conclusion of the year if an employee has a balance in excess of the 40-hour carryover requirement or upon termination of employment. Keep in mind that you're not required to cash out paid sick leave. You have that option to do so, but if you do provide for cash out, you can only do it in those 2 circumstances. So for example, if an employee has 80 hours in July, they come to you and ask for cash outs, you can't do that in that circumstance. You have to either wait until they're terminated to cash out, or at the conclusion of your year, if they still have 80, you can cash out the hours above 40 and then roll over the 40 to the next year. The next subject in the guidance that I wanted to touch on relates to PTO programs. So as most of you probably know, you can comply with Washington paid sick leave by providing a single bank of PTO that includes paid sick leave. The department notes that if your policy doesn't differentiate between paid sick leave, use of PTO for paid sick leave, and use of PTO for any other reason, then the department's going to apply the protections of paid sick leave law to all those hours, which is not ideal because if an employee comes to you and says they want to take PTO and they don't provide the proper notice, then the department looks at that, and whether it's for vacation or sick leave purposes, they're going to treat that all as falling under paid sick leave law. So it's critically important that if you do have a PTO program that is used to comply with paid sick leave, that you're differentiating between the use of paid time off for sick leave purposes and non-sick leave purposes. So for example, if you have a notice requirement, you have one notice requirement says if you use PTO for paid sick leave, you provide 7 days prior notice for foreseeable use or as soon as possible for unforeseeable use. And if you're going to use it for vacation purposes, maybe you provide 2 weeks or 30 days notice. The department's okay with that, but you need to spell that out in your PTO program. Otherwise, you might find yourself in a bind in terms of trying to manage use of PTO for paid sick leave purposes without that type of differentiation. So it just provides another tool in your toolbox to help manage those types of requests on your PTO program and not running into issues with the department. The other item is use of paid sick leave. The department affirms its position that the employer can't require an employee to use paid sick leave. It's up to the employee to do so. The good thing is the department acknowledge if they say the employee is sick and they could use paid sick leave and they decide not to, that now they're exposed to the employer's attendance policy. So it's kind of an odd position by the department, in my opinion, because it can put employees in a perilous position where they could use paid sick leave under the law. If they decide not to for whatever reason, maybe they want to preserve it for their trip whenever you can travel again. but the employee can then be disciplined or potentially terminated because they might have had an unauthorized absence. Just keep that in mind, though, that you can't require them to use it, but you can ask them. You can confirm if they email you or call in and say, I'm sick. You can ask them, do you want to use paid sick leave or PTO for paid sick leave? So that's permissible.
So paid sick leave has been real interesting. Obviously, COVID found some gaps, right, that a lot of this stuff is highlighting. And one of the challenges is getting people back to work. And so a question that came up is, if employers are requiring a COVID test before they do return back to work, does the employer have to pay for that test?
Generally, yes, they have to pay for the test. It's going to be, so the Oregon Osha rules that are going to go into effect in next couple of days require the employer to pay for the test explicitly. I believe Washington also requires you to pay for it. I don't know that off the top of my head, but I also think it's probably a good practice as well, assuming you can do it.
And we've seen sometimes multiple tests required as well. There's another one that I've seen a couple times.
Okay, so is it the employer requires multiple tests or the medical provider?
The employer was, yeah, that they wanted to. It's kind of like I don't know if they thought they were the NFL or not, but they were asking to see, I think it was 2 tests or whatever, showing that they were not positive.
Yeah, I think that goes to the question of the reliability that I talked about earlier, that my understanding, I'm not a medical expert, so you can take this with a grain of salt, but my understanding is some tests are more reliable in a single format, and other tests you might need to take it 2 or 3 times. Like I think it was Nick Saban or someone that took it.
Yeah, right.
Positive, some of them weren't. I was like, was he positive or not? So yeah, it goes to the type of test you're using.
So this is sparking some more. So if we've got time, we can stay on this. Well, I know we're running out of time real quick. Are you okay with a couple more of these, or did you want to? Okay.
Sure.
All right. So if the company paid medical insurance pays for the test, is that the same as the employer paying for it?
Yes, I would say yes. The information I've seen hasn't explicitly addressed that, but the idea behind the regulations I've seen is the employee isn't burdened with paying for it. So in my mind, if the insurer pays for it, all is good.
Yeah, what I found in practicality with that, the challenge is a lot of providers, just because this is the direction from the CDC, is that they don't show the actual symptoms, then they won't conduct the test. And the only way to get that is to have it paid for. So that's where insurance won't pay for it, but then the employer would. And so the employee is going to potentially get some inconsistencies unless you just say, hey, look, we're going to cover it through your insurance or not.
Okay.
Another one that came up is if we have a salaried part-time exempt employee that works less than 100% FTE, can we prorate the minimum Washington salary threshold for exempt employees based on their percentage FTE they actually work? Did you get all that one?
I think I did. So I think the question is, does the threshold essentially kind of like reduce on a pro rata basis based on the FTE status?
That's what I'm reading, yeah.
Okay, so if that's the questions being asked, the answer is no. The threshold is the threshold. You got to meet it whether they're working, 100% FTE, 60% FTE, whatever that might be.
Got it. Okay. I think that's the main questions we got in here. I know we're running out of time. How are you doing on slides? I know you had a lot of content you wanted to cover, and it's great stuff. I mean, obviously the questions are starting to get rolling. So
yeah, so I had some more I want to talk about for Oregon. Just real quick, I'll summarize it, and then because I tried to squeeze too much stuff into here, going back to me being perpetual optimist, I'm always optimistic I can cover everything. But if you're someone who has folks in Oregon and you want to talk about one of these 2 subjects, feel free to contact me and I'm happy to chat about it.
And Jim, are the slides on Oregon, are they in the details, are they in the slides as well?
Yeah, there's some information in there. So the first is the Oregon Workplace Fairness Act. The one in effect on October 1 has very specific requirements about written anti-harassment and anti-discrimination policies. In other words, you have to have one if you're an Oregon employer, and it has to have certain components. And so those are in here. And then the other update in Oregon that I've alluded to a few times is the new Oregon OSHA COVID-19 regulations, which are going to go into effect any day now. I think maybe later this week or early next week. If you have employees in Oregon, you need to look at those because they're now formalizing a lot of the existing requirements that we have in Oregon that were issued from various agencies and the governor, and they're bringing them within the Oregon OSHA enforcement apparatus. And there's a lot of them are similar to what you're already probably doing, but there's some additional steps you have to take. So I would encourage you to look at that and look at the slides. And then if you have questions, I'm happy to answer them either now or in follow-up.
And I think one of those ones, tell me if I'm wrong on this, is having like a COVID safety officer. Have you seen that in the regulation as well?
Yeah, so there are certain requirements in Oregon OSHA that you have people designated to address certain issues. Also require a couple of requirements. You have to do an exposure control assessment, so go through and assess risk of exposure. And then once you do that, you have to go through and develop a kind of a preparedness plan where you outline how you're going to address those risks that are present in your workplace. And then there's some industry specific requirements that apply to industries and operations like construction or retail or restaurants, whatever that might be. And there's some specific requirements in there for the risks that are present in those types of environments. Got it. Good stuff. Thank you. Oh, here's another one. If you're, we're going to keep this going. If you're a Washington employer and employees working in Oregon half the time or over half the time, does the Oregon Workplace Act still apply to those Oregon employees? Is this the question related to the Workplace Fairness Act or the Oregon OSHA or both? And I can answer it for both if that's the best way to go about it. It's not clarified in there, but so maybe just throw both in case someone else has a question, but they're looking at the other side of it. So the Oregon OSHA, the answer would be that if you have employees working on a work site in Oregon, those safety requirements are going to apply. So the classic situation would be, let's say you're a contractor, battleground contractor, not picking on anyone that might be on the call, but we all know there's a lot of contractors in battleground. You send some folks down to an Oregon job site, those Oregon OSHA requirements are going to apply. The Oregon Workplace Fairness Act, I would say yes, it will apply. If you have someone who say works out of a Washington office and maybe they're working remotely at home in Oregon, I wouldn't be too concerned about it. But if you have people in an office over there or some other kind of more sustained presence, then yes, I would suggest you comply with the Fairness Act as well. Okay. Perfect. We'll field a few more if they're there, or I think we're there. We probably need to sum it up at this point, but all really great stuff for sure. Okay. Well, like I said, I'm always happy to answer more questions. I know I kind of had to rush through the end, but I appreciate everybody attending. It's been enjoyable. And stay tuned. I'm sure we're going to see a lot more developments in the next couple of weeks and months. Yeah, it's exciting. Jim, thanks so much for sharing all the information. All these updates and everything that keeps changing all the time. I think you mentioned that 30 days ago, even some of this stuff is new and changed a bunch too. So we'll keep looking forward for those updates. Do you have a newsletter or anything that they could subscribe to pick up updates that you send out about? Yeah, so I'm happy to make a shameless plug. I do have an employment law update or bulletin or email list I use to send out these types of updates. If you want to sign up, it's on our website, Landerholm's website. For some reason you can't find it, shoot me an email, I'll send it to you. When I see hot topics, whatever, that affect the business community, I'll shoot out an email blast. Here's the information, so you're aware of that. It's a good way to try to keep up to date on what's going on in the world. Perfect. And as I mentioned earlier, we recorded the session, so we're going to send out a link on that, plus the slides with Jim's contact information. He's mentioned a couple times, reach out if you've got questions. He's always been great for us and to me on when I've got random things that I'm just kind of curious about or being asked about. So very, very helpful, and doesn't bill you for every 2 seconds that you talk to him. Maybe every 3, but at least not every 2. So thanks again so much, Jim, for joining us. We really appreciate it. And we'll talk soon. Good. Thanks, Tyson. All right. Talk to you later.